Wow, right out the gate this judge isn't playing. Did you catch that? Separate family and spectators? This courtroom runs on rules, and we're about to see how one parking ticket spirals into a major legal battle.
Are you embarrassed to be with your mom? Oh, okay. Got it. Okay. Good morning, Mr. Hardy. Mr. Hardy, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable...
Hold up, 18 inches. That's the length of a standard ruler. Let's be real. Was this really about public safety, or was it just a pretext to fish for something bigger? Spoiler, the officer smelled marijuana the second the passenger stepped out. Coincidence? Drop your theories below.
Because you have the right to remain silent. Anything you say can or will be used against you. The right to have an attorney present if you cannot afford one will be appointed.
On November 22nd, 2024, the officer observed the defendant's vehicle parked more than 18 inches from a curb on a public roadway in the right lane of the two-way road in Harris County, Texas. While the officer ran the motor vehicle, the passenger side door opened, a black female exited, and the female approached the patrol vehicle. The officer made contact with the female and observed a strong odor of marijuana emanating from the female. The officer made contact with the defendant and the driver of the vehicle, observed a strong odor of marijuana, and had the defendant exit the motor vehicle. PC search was conducted, and the officer located 3.5 in the driver's side door and one blue package with Oops All Berry on the front containing green leafy substance.
Oops All Berry, Fruity Pebbles. This sounds like a stoner's grocery list, not a crime scene. But here's the legal kicker. Odor alone can establish probable cause in Texas. So even if the parking stop was shaky, that strong smell just locked in the case. Brutal.
On the rear driver's side floorboard, one red package with Fruity Pebbles in the front containing a green leafy substance in the back seat, and two clear plastic baggies containing green leafy substance under the front and right passenger seat. He also observed one burnt marijuana cigar behind the front passenger seat and one small chunk of loose green leafy substance in between the driver's seat and the door. The green leafy substance was identified as marijuana based on training experience, and the weight was 54 grams or 1.9 ounces.
Alright, let's hit pause for a second. Did you catch what just happened? This entire case hinges on parking. Yes, parking more than 18 inches from the curb. That's the technicality the officer used to initiate the encounter. Now, here's the kicker. Would you be able to eyeball 18 inches from the curb at 4 in the morning? Let me know in the comments, because if this sounds like a setup, you're not alone in thinking that.
He was doing what that was wrong?
So he was parked more than 18 inches from the curb on the right lane of a two-way road.
How on earth are you going to know that you're parking more than 18 inches? What time of day or night was
Your Honor?
parking while black now?
Yeah.
Your Honor, there's no time listed. It just says the officer was on patrol around the 3518 block Arbor Glen Drive when he observed the vehicle parked more than 18 inches from the curb.
And so he goes up to the car because of that?
No, Your Honor, a female passenger side exited the passenger side and approached their vehicle, and he observed a marijuana plant.
Because he comes up to them. Right? Stop. Are you losing?
The officer wrote as he ran the vehicle, presumed the license plate.
Right, he pulls him over.
They were already parked on the side of the road 18 inches from the curb, and he came, I guess, parked behind, and he was running the vehicle, and then the passenger side door opened, black female exited and approached his vehicle, the patrol vehicle, and he observed an odor of marijuana on the female, and then he made contact with the driver, where he observed marijuana odor in the vehicle. So the female approached the patrol vehicle.
Show me in the penal code that code. What is the penal code for that?
Parking 18 inches from the curb, sir? Was that the
Yeah.
issue of what we're talking about?
Yeah, because they come to him because he comes to them. Right, they're just parked. He comes to them. It's got to be a transportation code, not penal code, you know?
So an officer eyeballed 18 inches in the pitch dark? Judges aren't dumb. This reeks of reasonable doubt. But here's the twist. The defendant's lawyer didn't challenge the officer's vision. Missed opportunity or strategic move? You tell me.
Your Honor, regarding the timeline of events, it does appear that when they were parked that distance away, which could be arguably further, I don't know what it looked like at that time, but the female passenger is the one who exited first, and that was before officers ever made contact with them. So I don't know if you were thinking that the officers approached them first, but I just wanted to clarify that she approached first.
What time of day or night?
I see that wrong. Four in the morning.
Your Honor,
4 in the morning.
4:30 a.m.
And you can delineate at 4 in the morning that parking 18 inches from the curb.
and I found the regulation, the statute in the transportation code where it says you have to park within 18 inches.
4 in the morning, you can tell.
Your Honor, the officer was.
I don't think so. All right, I'm gonna find no probable cause. All right, you guys, be careful. Right, you know, they're always out. Just be careful. Do something with your life. Knowledge is power. Get into school, get an education, do something with your life. Life is hard as it is. And it only gets more difficult the older you get. All right? Okay, please.
And we'll be sure to call the officer on this case to
Whatever you need.
understand why he did in fact pull them over for this amount of space.
Good morning, Mr. Williams. Mr. Williams, you stand charged with the offense of terrorist threat of a family or household member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. I have a lawyer here that's representing you now. She's on Zoom. It's Ms. Gooch, so that you know you're not alone.
On December 29, 2024, the officer was dispatched to a disturbance involving a weapon in the apartment in Harris Commission. The officer made contact with the complainant. The complainant said that she and the defendant are in a dating relationship. She left the club with a witness, and she received a call from the defendant asking where she was at. The defendant was upset because she was not at the apartment when he was there.
No, hold on. Don't look at this computer.
And the defendant was texting her that she better not be at the apartment, as that would be her best bet after she walked to the club and the complainant wasn't there. The complainant stated when she returned to the apartment, she observed the defendant walking towards the motor vehicle she was in with a black metal object in his hand banging on the window of the motor vehicle. The defendant told the complainant to get out of the motor vehicle or he was going to drag her ass out. The complainant felt threatened and called the officers. The defendant sent text messages to the complainant reading, "It's cool because whenever I catch you, I promise you on my life, bitch, I'm gonna show you. You can think I'm bullshitting. Let that bum ass have you. Y'all made for each other on my mama, so I'm telling you to stay where you at for real. But whenever you come here, bitch, you better have backup because I'm gonna go drag you, bitch."
Warrior, I brought him out, and the reason I did was because my concern is that your bond is now set at $10,000. There's got to be a reason, because nearly everybody now gets either a PR bond or a general order bond, and I'm curious, and
The judge just dropped the hammer. Past dismissed charges doesn't matter. The pattern is what counts here. This is why bond conditions exist, to protect victims before things escalate. Chilling reminder, the law cares about what's next, not just what happened.
I wonder why they didn't give you a bond. So I'm going to read now what the magistrate said. I don't know what these acronyms are. It says FA:LLHC, race, caretaker for disabled mom, independent contractor, receives government benefits, indigent. Defendant allegedly had a black metal object in his hand and threatened to drag complaining witness girlfriend out of the vehicle before punching the car window. Defendant also allegedly sent text messages to witness stating that he would punch complaining witness, quote unquote, dead in her shit on his mama. unquote. Criminal history, interference with the request for emergency assistance, 8-24, same complaining witness, dismissed, assault of a family member, impeding breath, 2021, same complaining witness, and other criminal history. I find by
This is where it gets real. Judge Fleischer just laid down the reason why the defendant wasn't granted a PR bond. Despite past charges being dismissed, the pattern of behavior with the same complainant, threats via text, and violent escalation, makes it impossible for the court to trust a low-level release. Legal question for you. At what point does a history outweigh a presumption of innocence? Comment below, this one's tough.
convincing evidence that there are no non-financial conditions of bond that will suffice to reasonably assure public safety for the following reasons. This defendant's numerous prior incarcerations and history of violence have not deterred this defendant from engaging in criminal conduct involving the same complaining witness. Bond conditions are not likely to be a deterrent, so a high bond is necessary in this case. This is why you are not given a PR bond. Don't say anything. I want you to talk to your lawyer before you say anything. Got a bunch of DAs here. Everything you say, they're going to sit there and they're going to type it to use it for guilt. So it's not my only problem. And I want you to understand that my only concern, Mr. Williams, is public safety. That's the only thing I care about in this life, right?
We no longer have no dealings with each other. I already got my stuff packed.
Stop. You don't have to say anything. You don't have to justify. I just want you to know that I don't know if you're going to bond out, but if you do, I'm going to put a monitor on your ankle prior to your release, so I know where you are, and I don't want you to have any contact with this person.
So no way I can get a PR.
There's a protective order that's been issued in this case. I would get to know it, because if you violate this protective order, the state can file a violation of the protective order, and that is a capital murder of misdemeanors. Pick up a VPO, we are really deep, you know what. So what I'm going to do now is I'm going to have you put back. I'm going to have Lori reach out to you so you guys can talk, and then she can come back and tell me how we move forward. Okay? And then we'll go. Please. Good morning.
More. Hold you on. Straight. Yeah, straight.
Treadwell. Okay. It's not old.
It's more so just the
Oh, she has 2 open DWIs. What are they? They probably want inpatient treatment. You know, I'm going to tell you that
This judge is done with second chances, and can you blame him? When courts ignore treatment recommendations, people get hurt. But here's the ethical dilemma. How do you balance rehab and public safety? No easy answers here, folks.
Brianna Treadwell, come up. Hey, and I'm so glad that Mr. Butler, you're here, because come up. Every time, I mean, I can't be that inclusive, but so many times when we do a TRAD, because I have clinicians that interview people and make recommendations, so many times when I don't follow those conditions, I get burned. I had one today that recommended inpatient treatment on an individual. He now put 2 people in the hospital and picked up a 3rd DWI, felony DWI, and he's sitting in custody at a $75,000 bond because I didn't follow the TRAS, recommended inpatient treatment, and now 2 people are in the hospital, serious injuries because another gentleman here back there, we did a TRAS, I didn't follow it, picks up another DWI with another pending, and then the TRASs are there for us. We have professionals, we have clinicians interview and make a call what they think the best outcome is for certain individuals. Now, you have to open DWIs, and they take all these things into consideration, how to move forward with the case, because believe it or not, we want the best for you. We want you to leave better than you came here. And just so many times when I deviate from that TRAS, we end up getting burned. I can't tell you over and over and over. And that's the last thing that we want. What did it recommend? Yep.
Miss Treadwell, she has 2 young daughters. One of them is special needs who applies facial therapy and speech therapy. That happens once a week. The other one in middle school age. Miss Treadwell, she was in custody for about a month and a half. And it was very difficult, extremely difficult for her family to even try to coordinate things with her daughters. And then as well to Miss Treadwell, her home. So Miss Treadwell, she needs to work. She has bills, as everyone does. And all of these other circumstances with the children. It's at least looking at it, from Miss Treadwell's perspective, it seems impossible for her to go into treatment inpatient. And it's hard to see that other side. What does that other side look like? And so the kids were staying with her parents. Her mother just got surgery, hip surgery, and they broke her femur in doing so. She's out of commission. Her brother was staying with her parents at the time. He is about to now move to Chicago. So they don't have the same system as they had in place while she was in. She was very much in custody based on, her parents believed that, this was an issue. This is, on its face, you look at it. It's definitely an issue. Not to say that she has paid a price at all, but and her intention is to do what's needed. She has explored all of these options, with respect to even the Vivitrol Vivitrol. She has explored options through access. She has been making those steps. My belief is that she has, I don't want to say learned her lesson, but she has.
I'm going to leave it for a sec. Well, telling you, she has 2 open DWIs. Mm-hmm. And every time I deviate from the TRASs, we get burned. And now, just today, 2 people in the hospital because we deviated from the SATF, and homeboy picked 3rd DWI.
Yeah, and I was made aware of that prior to us even approaching.
Last thing I want is for you, because the idea of Hue is that you are able to learn how to deal with the stressors in your life, so that alcohol, substances don't become coping mechanisms, right? And I don't know what to tell you, but actions have consequences, and I understand that, you have a lot of things in your life that are going on now. The only thing I can tell you is that your case is only 118 days old, so it's not too old.
And there it is, the moment of brutal honesty. The next one is 2 to 10 years in the penitentiary. That warning wasn't just for Treadwell, it's a message for anyone skating close to the legal edge. Think about it, one more slip, and your life path changes forever. Do you think the court is being too harsh here? Or is this tough love justified?
Give you time, right, so that you can get everything in order, but I'm going to be very hard pressed to move away from the TRAS. Just we have